staggering problems of poverty and inequality. So that's the context within which courts function. Another context within which courts function is there is a growing disenchantment, if I could call it that, with what people say is a constitution that doesn't serve us well. I can understand the disenchantment and I can understand the disillusionment, but I'm not sure if it's correct to characterize the problem as being the one located in the constitution. I would rather say the problem lies in our collective inability to convert the promise of the constitution into reality, to convert the promissory note that this constitution represents into reality. And that's something we need to think about. Because in the work I've done, even before I became a judge, many people would say to me, and I recall a visit I made to a village called Khapasha, deep in Skukuni, where an old man said to me, "It sounds like you like this constitution because you speak about it with great passion. But if I may say so, it also seems, judging by the car you've driven here and the suit you're wearing, that this constitution has worked for you." And I thought that was a fair comment. And he said, I hope you understand that one day when it works for me, I will probably be more passionate than you are about it. And I think that's a fair comment for people to make. And so that's the context within which courts then find themselves. And just 3 or 4 features in the challenge that we face. The one is around transformation. And this word transformation has been used in different contexts, but it's important. It's important because we have to change the DNA of the society. And we have to locate the work we do within a common understanding of the values that underpin this constitution. And the optics of transformation are important in terms of what a court must look like. But I think equally important is the values that underpin that transformation. And transformation is not an easy thing. It creates discomfort, it creates uncertainty, and it creates insecurities. Because truly what we are required to do in the process of transformation is to examine ourselves, is to examine our own biases, our own prejudices, and that's more difficult. And we see in our society every day the discomfort that often attaches to debates around transformation. But I would like to think, and I say this even as a judge, that the journey begins with me. And I can do no better than to quote from Stephen Klingman's book called Brown Fisher, Afrikaner Revolutionary. You will recall Brown Fisher was the lead counsel in this court and a year later he was arrested and sentenced to life imprisonment, released at a time when he was terminally ill. But a remarkable man. But this is what Stephen Klingman writes about Brown Fisher. He says, he came out of Afrikaner nationalism. He died belonging to the whole of South Africa. He never saw this as a betrayal of Afrikaner identity, but rather as its fulfillment, the extension towards the true meaning of the name African. And while Stephen Klingman was writing about Brown Fisher, I think what he says is relevant to all of us, how we undertake our own journey of transformation. And so that's important in the broader context of our society, but transformation is then equally important in the context of the judiciary. So that people walk into a court and feel confident that they're being tried by a bench or by a system that represents them. And that doesn't mean that as a black person you're entitled to ask the black judge to sit in judgment of you, or as a white person. But it's a system that represents the diversity of our nation, and it's what former President Mandela spoke to when he sought the recusal of the magistrate that was unsuccessful. The second and difficult issue is around the separation of powers. And we don't function in a system of parliamentary sovereignty. The Constitution proclaims its sovereignty, and it mandates in section 172 that a court, when dealing with a constitutional matter, must declare law and conduct that is inconsistent with the Constitution, inconsistent to the extent of its inconsistency. That has been the subject of much debate, because there have been debates and arguments that on the one hand, courts overreach, they stray into the lanes of the other arms of government. And on the other hand, there have been criticisms that courts are conservative, not politically, but conservative by nature, and they exercise too much of deference towards government in claims, in particular around socio-economic rights. I think those debates are healthy and must continue, but I simply wish to make one point there, and that is that because of the supremacy of the Constitution and because of the powers that a court must exercise in terms of section 172, if a court intrudes into assessing the work of other arms of government, then it does so not because it simply elects to do so. It does so because the Constitution mandates it to do so, and the Constitution contemplates that it must do so. And so this argument that courts don't interfere where they shouldn't, I think is misplaced. On the contrary, I think too many matters come to courts. I think there's an over-reliance, as it were, on courts to find the solutions to the problems that society faces. And I'm not sure if I'm equipped to deal with a dispute within a religious community, for example. I know I had to deal with a dispute in a church involving, I think, 3 million Christians. And I said to them, I have great faith in you because you've chosen a Hindu that wears a red string to try and resolve your dispute. I thought they would ask for my recusal, but they didn't. But the point is simply that that's what happens. And I think that in a democracy, the best guarantor of democracy is when people engage with their government. And Amartya Sen, the Nobel laureate, was in South Africa many years ago. And he spoke about the two perspectives of democracy. One, he said, was the public ballot perspective, which is the adequacy of the public ballot, and something that has played itself out in the last 3 weeks or so in South Africa. But the other is what he called the public reasoning perspective of democracy, what he called the ability of government to respond to public reasoning, what he called government by dialogue. And I think that's what we may be missing in a large measure in our democracy, the ability of government to engage in discussion with its citizens, to listen and to be responsive. And courts don't function that way. Courts don't function in a participatory way. And litigation is limited. It's an important tool, but it has its limitations. It's issue-based, it's evidence-based, it's costly, and it takes time. And so I've read somewhere that the worst thing a public interest lawyer could do is to take a case and litigate it in court, when that same case can be won in the court of public opinion. And so, lastly, in the challenge that courts face, I think the issue of access to justice is one that remains a major concern. It's concerning because in a rules-based society, and in a society where we encourage people not to indulge in self-help, but to use the mechanisms of the law to resolve their dispute, then in a society underpinned by the deep levels of poverty and inequality that we see, millions of people simply don't have the ability to access the law because it costs money to access the law. And ultimately, the quality of the legal representation that you can afford has an impact on the quality of the case that you can advance. And that must be worrying to all of us. I mean, in our courts every day, people lose their homes, their only place of living, in cases where they are by and large unrepresented. You may say they may not have a defense, but at the very least the court should be able to hear what their personal circumstances are about before deciding on execution or eviction. But that's just one example. There's so many cases that come through our courts, and it mustn't concern us that there's such a distance between the promise of the law and the ability of people to exit it. Then ultimately it's a further threat to the fragility of our young democracy. But I'd like to think that 30 years into democracy and 60 years after the sentencing in this court on the 12th of June 1964, the fact that today we as South Africans can sit here and celebrate their lives, celebrate their achievements, and openly and honestly reflect on where we are as a society is a wonderful testament to our democracy. But it's also a wonderful opportunity for us to pay homage and to recognize the enormous contribution that they and millions of others made so that we today could live in a free and democratic society. Not one without its blemishes, not one without its formidable challenges, but quintessentially a society so much better than the one in which I grew up in. And so, even in these anxious and uncertain and difficult times, I feel enormously proud to be here today and to be able to call myself a proud South African. Thank you very much.
Thanks, Justice Colopin. I want to there are 3 sons of 3 of the Rivonia trialists here. Max Sisulu, Salom Langeni, Koketso Motsoledi, who's just there. And then because Ahmed Kathrada didn't have any kids, his niece is here, Zora Arrington. She likes to call herself Kathrada still, but she's an Arrington. And I'm not sure whether any of you have ever sat in the dock in this court, but 60 years ago, your relatives, your fathers, in your case your uncle Zora, that's where they sat. And where they heard that they were going to spend this time in prison. Ahmed Kathrada writes, on a bleak midwinter morning in 1964, cold, wet, icy, windy, 7 prisoners were landed by plane on Robben Island, the prison off the coast of Cape Town. They might be described as South Africa's magnificent 7. There was an 8th person, but he was white and sent elsewhere. Though there was nothing magnificent about the physical appearance, they were tired, unshaven and unkept and shackled together. The day before, 12th of June in Pretoria, they had been sentenced to life imprisonment at what has become known as the Rivonia trial. They had narrowly escaped the death penalty for their political beliefs and activities against the nationalist government. Their names were Nelson Mandela, Govan Mbeki, Raymond Mhlaba, Andrew Mangeni, Elias Motsoaledi, and Walter Sisulu. The youngest at 34 was Ahmed Kathrada. Kathrada gets released 1989 at the age of 60. 34 to 60. We are marking the 60th anniversary of the trial here today as well. There's tons of emotions that family members will share with you. But what we thought was important in this court today was to hear the actual voices of some of the trialists. So we're going to play Madiba, a few minutes of Madiba's speech. Excuse the sound, it's a bit crackling. But the recording of the trial, fortunately the French government assisted arts and culture here to get that downloaded and into a usable form now. So the recording of the trial, at least the audio recording, is available, although we're still waiting for Arts and Culture to give us our set of it, and hopefully that will come at some point in time. But if you bear with us, we will just play for you a few minutes and you'll hear the closing of Mandela's address from the dock as well, in his own voice. Daud?
Is the gate here, and not imaginary huts, or to use the language of the state prosecutor, so-called huts. South Africa is the richest country in Africa, and will be one of the richest countries in the world. But it is a land of extreme and remarkable